I have a plethora of rights that are granted to me from God, the Human Declaration, from the Constitution, and so forth. I was attacked by some people, and I was protecting
Sir,
my life.
I know you don't
Okay.
want my representation, but I would advise
No, ma'am. No, ma'am. No, ma'am. No,
I would
ma'am. Please
advise that
don't.
you not
Please
talk about
don't.
anything that happened.
Please don't. I have reiterated that Latavius Treshaw Thornton is a nonprofit organization. I am not a surety. I am shoulders.
Do you have a medical marijuana card?
Mr. Thornton does not know.
Was the GPS ordered if he was released?
That's not necessary.
No.
This so-called sovereign citizen showed up in court and immediately proved how badly he had messed up. He's facing serious charges for allegedly assaulting 3 police officers. Yet he stood there telling the judge that his name is a non-profit LLC and that he's somehow innocent. Throughout the hearing, he wouldn't stop talking, rambling non-stop with the same tired pseudo-legal nonsense. Watching it unfold, it's honestly hard to tell whether this is willful ignorance or something deeper going on. Either way, it's baffling how someone can reach adulthood without realizing that this kind of behavior only ends one way: getting completely shut down by the court.
My representation at this arraignment.
Okay, and Mr. Thornton, could you state your name for the record, please?
I will object to being called Mr. Thornton. I am, for the record, my name is Shoulders. I am here as legal representation for Latavius Treshaw Thornton, which is the nonprofit organization.
Your Honor, I am looking at his file from 2022. I think he was sent to competency back in 2022, and it looks like it's going to be the same issue today. It's my understanding that he might have a bench warrant out for his arrest for sentencing. He pled guilty to, I believe, attempted R&O in November 8th of 2022, but he failed to appear in December 2022. And looking earlier in the files, I believe he was sent to competency as well. And it looks like this is going to be the same issue. So if the court is inclined to send him to competency, I'd ask for that.
Objection again, Your Honor.
Everything comes through me. You're going to get your turn, okay? But I have to run this in sort of an organized fashion, in part for you, because if you want to appeal, you want a transcript that is coherent and readable, okay?
I'm sorry. I don't know. Were you speaking to me or
yes,
to
sir,
Mr. A?
Mr. Thornton. So if you want to appeal, you
want. I just want the record to be correct, and there was no objection. There was no objection to the statement that I made about Mr. Thornton, about Latavius Treshaw Thornton being a nonprofit organization, and I was just objecting the points that the attorney prosecutor made.
Okay. But yes, there aren't objections at arraignment. There aren't objections at arraignment. And I am going to call you Mr. Thornton because that is the name that you have been identified as, and that is the name the charges are under. No, Mr. Thornton? So, I mean, the other option is to call you defendant, which is true. You are the person defending yourself, but that sounds kind of rude. So I'd rather call you Mr. Thornton. So I want to make sure that we treat you with as much respect. Here's why we have this hearing. You have, under the Constitution, a Sixth Amendment right to know the charges against you. So we have this hearing for that reason. So I want to make sure that you get all of your rights and know everything that is available to know about this case right now so you can defend yourself. That's the whole purpose today. To give you the information you need so you can defend yourself with or without counsel as you wish, okay? We're going to do 5 things this afternoon. First, I'm going to read the charges against you, including the maximum possible penalties, because you have a right to know them. Second, we're going to talk more about your rights. Then, I'm going to enter a not guilty plea on your behalf. I'll give you the opportunity. Well, no, sir. So just a minute. Okay, so you're going to have the opportunity. You can stand mute or plead not guilty. We'll come to that in a minute, okay? So that's the third thing we're going to do. Then, we're going to talk about dates when you return to court. You're going to get those in writing. Lastly, we're going to talk about bond or bail.
Can I please?
Because here's the thing. I don't want to be disrespectful to you.
Right, absolutely.
Sovereign citizens never seem to care about basic respect or courtroom decorum. They act like the court revolves around them, as if they're the star of some imaginary legal drama and everyone else is just background noise. This might sound harsh, but judges should be firm and shut that behavior down immediately instead of letting it drag on. When a judge is clearly trying to move on to the next case, interrupting is nothing but a waste of time for everyone involved. There is a proper time and place to speak, and randomly talking over the judge is not it. If someone wants to make a speech, they should wait until the actual hearing when it's at least relevant. Zoom court only makes this worse because people get too comfortable behind a screen and start acting like it's a casual video call rather than a real courtroom.
Thing that could come back to haunt you later. So that's why, and this is true of every arraignment I do, I tell people right at the beginning, if you try to speak, I'm going to shut you down. And it's not to be disrespectful, and it's not because the case has already been decided. It's to protect your innocence and your interest going forward. So for that reason, I'm going to do most of the talking here.
That's fine, Your Honor. I'm
Okay,
fine with you doing most of it. But please, to protect my free speech, could you please not mute me? I have no intentions of disrespecting your courtroom. If I speak out of turn, could you just simply let me know? And
Okay.
I am aware that I am innocent until proven guilty, and that something I say could, like you said, come back and haunt me. I'm well aware of that for Lieutenant Sheriff Thornton. However, I do still need to express correctly, and if I'm capable of settling this matter now, why can't we do that? I have more than just the Sixth Amendment right. I have a plethora of rights that are granted to me from God, the Human Declaration, from the Constitution, and so forth. There's a plethora of rights that have been granted onto me. So I don't just want to rely on the few far in between. I would like to rely on all my rights and abilities, and if possible, take care of all these matters in the most dignified and respectful way to keep the court's dignity and my dignity as a man. And furthermore, as a preservation of my innocence, I would like, until proven guilty, I believe that is pertinent that the innocent factor be imminent here.
Absolutely. So here's what I'm going to tell you. And I tell this to everyone at this stage. The most important thing I can tell you this afternoon is that you are innocent. You are innocent unless you remain innocent, unless at some point you plead guilty or are found guilty beyond a reasonable doubt at trial. And I say unless for a reason, because it's different than until. And now I'm going to read the charges against you because you have a right to know them. Okay? You can't really defend yourself unless you know what you're accused of. Maybe you remember being a little kid and going to the principal's office and not knowing what you might be in trouble for. No? Okay. Well, you were probably a better little kid than I was. But I'm going to read the charges against you. It's going to take some time reading all the way through them.
Before you get to reading, can I make one statement, please?
Well,
Your Honor?
You can, but let me read through these first, okay? Let me read through these first because I want to make sure I cover everything. The other thing is judges use scripts. And the reason we use scripts is to make sure everyone gets all of the information and to make sure we treat everyone the same.
I'm aware of that, Your Honor. And that is why I feel it necessary for me to make certain things known for Lieutenant Sheriff Thornton, for that the script so we can stay in honor. Once again, I have no intentions on dishonoring the courts. I'm even here to surrender all of the interests of Lieutenant Sheriff Thornton to the courts. That's I have those full intentions. And so that you guys can be safe from all liability of Latavius Treshaw Thornton as his representation. That is the only reason why I speak in the way of please refrain from calling me Mr. Thornton and certain things, because it's pertinent for you guys to know I've already been treated as the surety. I am not the surety. I'm really shoulders. Like, if you guys meet my people, you will find out I'm really shoulders. Latavius Treshaw Thornton is really a nonprofit organization, and I am not a surety for it. And it is a company, and it does not profit. So with that information, I understand that the script goes a little different, and I understand that. I have the right to let it be known that I'm not the surety, and nobody has. I'm sorry. And
okay, all right.
Yes,
So basically, this guy is standing in court claiming, "My name is Shoulders, trust me." As if that's supposed to mean anything legally. First of all, what kind of name is that? And second, the law doesn't care what you feel your name is. You could say you're a helicopter, a toaster, or a whole transformer, and the court would still call you by your legal name. This isn't a nickname contest or a personality showcase. It's an actual legal proceeding. What really blows my mind is the judge just sitting there letting him rant like it's open mic night at a coffee shop. At some point, control of the courtroom has to matter. Watching everyone quietly tolerate this nonsense is honestly embarrassing. And I'm shocked this guy hasn't been muted yet. Let me know what you think about the judge here, because this whole situation feels unreal.
5 at Cary Street and Lake Lansing Road in the city of Lansing, zip code 48912. You did assault, batter, wound, resist, obstruct, oppose, or endanger Kayla Bevere, a police officer with the East Lansing Police Department, that the defendant knew or had reason to know was performing his or her duties, contrary to Michigan law MCL 750.81D1. This is a felony, punishable by up to 2 years in prison and or $2,000 in fines. In count 2, you are accused of assaulting, resisting, or obstructing a police officer, again, on or about March 9th, 2025, at Cary Street and Lake Lansing in the city of Lansing, zip code 48912. Specific allegation is that you did assault, batter, wound, resist, obstruct, oppose, or endanger Chris Shattuck, a police officer with the East Lansing Police Department, that the defendant knew or had reason to know was performing his or her duties, contrary to Michigan law MCL 750.81D1. This is, again, a felony, punishable by up to 2 years in prison and or $2,000 in fines. Lastly, in count 3, you are accused of, again, assaulting, resisting, or obstructing a police officer. And the specific allegation is that on or about March 9, 2025, at Cary Street and Lake Lansing Road in the city of Lansing, zip code 48912, you did assault, batter, wound, resist, obstruct, oppose, or endanger Colin Lemire, a police officer with the East Lansing Police Department, that you knew or had reason to know was performing his or her duties, contrary to MCL 750.81D1. This is, again, a felony, punishable by up to 2 years in prison and or $2,000 in fines. Now, how do you wish to plead?
I don't. You said a lot, so can I address them part for part first?
No, not right now. So here's what I'm gonna do. Here's what I'm gonna enter. I'm gonna enter a not guilty plea on your behalf, and here's why.
Can I ask you this first before you enter that plea? If me giving you a plea right now, will that be in response to everything that you just said?
Nope. So a plea would have you pleading. Would have you pleading guilty to all those charges. We've got some back and forth here. It kind of sounds like we're underwater. So a plea would have you pleading guilty to those crimes, 3 felonies, without having seen the evidence against you. So you can stand mute and the court enters a not guilty plea, or you can say you want to plead not guilty and you would be not guilty. Then what happens next, and here's why, then you have a chance to get the evidence against you and to consider it, among other
So
things.
it's a bit more to it, Your Honor. That's the issue. So I will, based off of the things that you stated, that's not what my understanding is. From my understanding is I was attacked by some people and I was protecting
Sir,
my life.
I know you don't want my representation, but I would advise.
No, ma'am. No, ma'am. No, ma'am. No,
I would
ma'am.
No, seriously, this guy is completely sabotaging himself. You can almost imagine the prosecution watching this unfold like a cartoon villain, patiently waiting for their moment to tear him apart. After everything he just said, it's painfully obvious he desperately needs a lawyer. This is not a YouTube apology or a rant session. It's a courtroom with real consequences. Sovereign citizens do this all the time. Show up to an arraignment and immediately start declaring their innocence like that's how the system works. Being loud, emotional, and wrong doesn't earn you points in court. It just digs a deeper hole. I honestly don't understand why they refuse to speak to a lawyer for even 5 minutes, because talking about case facts like this is one of the worst moves you can make. Let me know in the comments whether you think this behavior comes from delusion, denial, or pure ego, because at this point it's hard to tell.
Thank you so much, Miss Melissa, but please do not intervene. Once again, back to you, Your Honor. From my understanding, I was assaulted, and I am shoulders. Once again, I have never told anyone. Wait, I don't want you to mute me, Judge. This is going back to this situation. Okay, thank you. I never told anyone that I am Latavius Trayshawn Thornton. Not one time. I have reiterated. I am shoulders, Latavius Trayshawn. Not just to you, Your Honor. That's so to be redundant for the record. Okay. I have reiterated that Latavius Trayshawn Thornton is a nonprofit organization. I am not a surety. I am shoulders. I am appointed to be an administrator for Latavius Trayshawn Thornton. No, that's why I'm here, but not a surety for Latavius Trayshawn Thornton. Furthermore, Your Honor, my understanding is I was attacked and assaulted, and I'm not sure if I could let that be known to you so that we can make that case come about, because I would like to seek forward that using the evidence from this, all the evidence that they have gathered. I would like to use it in my assault case against East Lansing Police Department and its agencies.
Now, next up, we have some dates when you're going to return to court. And let me just pull those up here. Okay, we're done. Okay, go ahead.
Yes, I just wanted to speak on my previous court history and let you know why it may look the way it looks.
Okay, no, here's the thing. I'm going to ask you to not say anything because I don't want to accidentally become biased.
Gotcha.
So, all right, so here are the dates. All right, you're going to come back for a probable cause conference at 8:30 a.m. March 21st. Now you're going to get this in writing, okay? 8:30, March 21st. We're going to move on to bond or bail. So would you like to be released on bond or bail?
Could you explain the difference to me, please?
Your Honor, I was gonna ask for a bond. People
Okay.
have.
We're going to let Mr. Anid go first. All right, Mr. Anid?
You know, the people are looking at MCL 765.6, some of the factors to
Now
consider.
you're cutting out. I'm sorry, go ahead.
If he says something like that, would it make you biased? Couldn't you be speaking to make you biased?
Well, I'm going to come back to you in just a minute, okay?
Okay, no problem.
All right, Mr. Nid, I'm sorry you were cutting out, but please.
Your Honor, the people are looking at some of the factors to consider bond. The people are asking for at least a $25,000 cash surety and GPS tether if he does post bond. We're looking at the seriousness of the offense charge, the protection of the public, the previous criminal record, and the dangers of the person accused, the probability or improbability of the person accused appearing at trial of the cause. All those factors are not in favor of the defendant, Your Honor. He failed to appear for sentencing in, I believe, circuit court. And again, Your Honor, if the court has updated lien, if you can see if he has a warrant from a couple years back, that's for pleading for attempted resisting and obstructing, is what my note indicates. Protection of the public, Your Honor, this case involves assault on officers. I think one officer got punched in the face. The previous criminal record, he has 4 criminal histories from 4 different states, Your Honor, pending from.
Okay, no, he's gonna get, and then I'll hear from you, okay?
And his
I don't
probably,
know.
Your Honor, lastly, he failed to appear for several years on sentencing. He's not going to appear for this case if he gets released. I just asked for a high bond and a GPS tether if he posts that bond. There's a lot of risk to the public in this case, and he obviously he has ties to Indiana, Kentucky, Georgia, and one other state, Your Honor. This is a problem.
Okay.
Thank you.
Okay, now,
Before we get to bond,
okay, I'm gonna give you a chance, but here's the thing. Because there are certain key words, because there are specific things attorneys ask for, do you want Attorney Vachon to address this on your behalf? Because she's really good at this. I will tell you, she's really good at this.
can I say some things to Attorney Vachon before I make that determination right here?
Yes, Your Honor, could we take a brief recess and I could have a breakout room?
Okay, so you're gonna be in a breakout room with just Attorney Vachon, then we're gonna come back. Nobody's going anywhere until after you've had a chance to come back, okay? One moment, please. We'll put you in a breakout room. Thank you.
Thank you.
Okay, so I'm gonna start with, Mr. Nate has spoken. I'm gonna start with Attorney Vachon. Attorney Vachon, anything from the breakout room?
No, Your Honor, the defendant will speak.
The very first thing out of his mouth was that he's not a flight risk, and that alone sets off alarm bells. When a defendant brings that up unprompted, it usually sounds more like deflection than reassurance. In this situation, where he's accused of assaulting 3 police officers and allegedly punching one in the face, the court has every reason to be cautious. A judge can't ignore the seriousness of those allegations when assessing public safety. Statements like this don't help his case. They actually make him look more concerning. It feels like a preemptive excuse rather than a calm, rational defense. And honestly, this is just the beginning, because what he says next makes it even clearer that he's not taking the legal process seriously at all.
Here, also, he has a lot of things he do here. He's a coach for 4th grade, 5th grade, 6th grade basketball teams, and they play year round. He's also a mentor to young children and to people who have had traumatic situations. They call on a daily. He's a counselor to the community and to the public. Furthermore, he's not a danger to the community or based off of his innocence, and he's not a threat to anyone in the society. He is actually beneficial to Mr. Thornton is actually a beneficial role in the community, and kids and multiple different areas of people, they look up to Mr. Thornton, and they will attest to his character as an upstanding, nonviolent, peaceful individual who brings smiles and love to the community. And he, once again, may I reiterate, is not a flight risk. Yes, he has ties to other places, but those ties are not as pertinent as to the ties of where he originally was born and reside and has grown as a part of this community and in a very effective way.
Okay, thank you. That's very well said. Sounds like Mr. Thornton really has a lot of good qualities. Okay, so I am looking at the file, and I want you to bear with me a bit. There was a song when I was younger. When I was in high school, there was a popular song that said, "Cruel to be kind." Okay? I'm looking at this, Mr. Thornton, and there's a warrant out of 30th Circuit Court, downtown, East Lansing. Okay?
Yes.
And this is from 2022, and it's a statewide pickup, no bond with extradition. So here's what I'm going to do. I'm going to come back to that in just a minute. I'm going to set a money bond of $10,000 because all of the days that you don't post that bond, you will get credit for the time. If I gave you a cash bond, what would happen is Ingham County would...
If you take a step back and really look at what's happening, it's honestly hard to believe how ridiculous this situation is. There's no realistic way this guy actually thinks he can beat serious charges by claiming he's an LLC instead of a person. He's not a business entity, he's just creating chaos for himself. The idea that walking into court and saying, "I'm a corporation," is some magical legal loophole is beyond absurd. It makes you wonder how we ended up here as a society. As a kid, I thought the future would be flying cars and robot assistants, not people trying to trademark their names to avoid accountability. It's sad on one level, but also darkly hilarious to watch. In the end, I'm glad the judge set a $10,000 bond, because anything less would seriously make reality feel broken.